the various other international forums. And Jyoti, we have heard a commentator from the Human Rights Office with the experiences in Sri Lanka also and Nepal. And she can well give Dr. Vidya Kishore Rai.
Namaskar to everybody. I am Vidya Kishore Rai Bimal from the Faculty of Law. Of course, it is a matter of great pleasure for me to have the chair of this qualitative and prestigious session. And the session is on socio-economic rights and their enforcement. And we are having two presenters regarding the issues. One is Mr. Vicent Cladderhead, and he will have his deliberations on enforcement of socio-economic rights under the draft constitution. And the other eminent personality is Dr. Mario Gomez on comparative experiences with regard to social economic rights. These two presenters are here, I think. And we are having three commentators, and I see that they are all from our country. The first one is Vinod Chaudhary. I think that he will be coming. He's not here, and he is the CA member, eminent constitutional expert advocate, Dr. Bhimarjun Acharya. And the next one, Jyoti Sangahara of HCHR. So we have this framework, and particularly we have the time constraint. We are half an hour late. It is 11:45, and it was required to be conducted at 11. So we are quite late. So I will request the paper presenters as well as the commentators, by taking into consideration the time constraint. And for this, first of all, I will like to request Mr. Vicent Cladderhead on enforcement of socio-economic rights under the draft constitution. That is in the process, and not going the time frame beyond from 15 to 17 minutes, and that is to be taken duly into consideration by the paper presenter, Mr. Vicent Cladderhead, on enforcement of socio-economic rights under the draft constitution.
Country Director for ICJ Nepal. I've chosen to stand up this morning for a couple of reasons. One is that having sat primarily at the back of the room yesterday, it appeared to me that a lot of the time we couldn't actually see the speakers. So in an effort to facilitate that, I've chosen to stand up, but I promise you that that doesn't mean that I'll speak for a longer period of time. As with several other speakers, I am from Canada, and I am very pleased and privileged to have been asked to speak at this event. It is a tremendous honor, and I speak to you honestly in that way. I also want to say that I don't come from Canada from the perspective of saying the way we do things in Canada is the way you should do them. I don't come from that perspective. In fact, I come from a different perspective, one that says, in all honesty, the way we have done things in Canada, and I'm particularly thinking of Aboriginal people in Canada, I also am of the view that when it comes to fundamental rights in Canada, we have made several mistakes. In our Constitution, in our Charter of Rights, the economic, social, and cultural rights are not explicitly laid out, and that, I say, must be seen as a mistake. And I urge you, as someone who has only worked with poor people for the last 25 years, I urge you not to make the same mistake. Copies of my presentation are being distributed, but what I want to say is I've divided into several parts. The first part is, why are ESCRs? Why are economic, social, and cultural rights needed? I think they're needed for several reasons. If we look historically at Nepal, women, ethnic groups, caste minorities, people with disabilities have been subject to terrible social injustice. The history of Nepal is a history of social injustice for equality-seeking groups, for minorities. That's one reason. If we look currently at Nepal, moving things forward, let's take just a very quick snapshot. And on my presentation, you'll see a list of things. But let me just look at a couple. Last year, in May through August, there was an undeclared cholera epidemic in Nepal. About 400 people died from it. And of those 400, when we break down the numbers, we see that even though Dalits were less than 15% of the total population in the affected districts, they made up almost 40% of those affected. There was a disproportionality. To anyone looking at it, you need to ask the question, why was it that Dalits were far more likely to have died? And then you'll see on my presentation, there are other ones. 43% of Nepali adults are illiterate. Of Nepal's 29 million population, only 1.6 million households have access to electricity. And it goes on and on. So not just historically, but the current picture is one of social injustice. A third reason, and as a newcomer to Nepal, I say this with some modesty, but when I've spoken to people here from all sectors, from all political perspectives, I ask about the conflict. What are the roots of the conflict? And to my amazement, what I find fascinating is that all perspectives say one of the most important roots of the conflict was social injustice, was poverty, was marginalization. Those were the roots of the conflict. And so I think that that is another huge reason why those roots, the social injustice roots, must be grasped, the nettle must be grasped and reflected in the new constitution. The last reason is that, as with many other forms of human rights violations, they often arise from political marginalization, social marginalization, voicelessness. People without a voice in the political process, everywhere in the world, including in democracies, have experienced human rights violations. There's no democracy anywhere in the world that has not legislated and enacted human rights violations. And the reason often is because those whose rights are violated do not have a voice politically. And so when we bear that in mind, it makes all the more reason why those who don't have a political voice should have recourse to the courts to ensure that their fundamental rights are protected, because history has shown us that politically and historically, they do not have access to the political process. Political elites have shown historically they are indifferent to those who are most marginalized. As a result, those who are equality seekers need to have access to an independent body which will enforce their rights. Just briefly, what are social and economic rights? The rights, for example, to food, to clothing, to housing, to health care, to education, to employment. These are the kinds of rights that are required to be protected in order to live a dignified life around the world. Notably, South Africa, applying those rights and showing the rest of the world that those rights can not only be protected, but also applied. So the right to housing, the right to food, the right to water, Constitutional Court of South Africa in a way that has become meaningful for those who are most. What kind of duties do ESCRs impose on governments? What is the nature of the bottom of the second page of my remarks? It's to apply the maximum of available resources. Progressive realization using the maximum of available resources. Right to food. Short answer, a non-legal answer would be to say Government must do what it reasonably can. They need to be able to go to court and hold government accountable for its lack of action. They need to be able to go to court and say, my rights have been violated. I want a judge to look at the evidence, to look at government's responses, and to say whether that's reasonable in all the circumstances. No more and no less. The fact that this can be done is shown in the South African experience. And in the third page of my remarks, you'll see there's a recent case from South Africa where people in Johannesburg said that they were not getting enough water. The government quota, I think, of 50 liters either per person or per household per day was inadequate. They filed a claim. The claim ended up in the Constitutional Court of South Africa. The court then looked at all the evidence. The plaintiffs went forward, filled all the evidence about the inadequacies, the unreasonableness of it. The government came forward and said, with respect to water, we have a program, we have targets, here's how we have prioritized disadvantaged groups, here's the resources we have available to fulfill these rights, we're doing what we can. And at that point, the court looks at the text of the provisions and then asks itself whether government's efforts have been reasonable, taking into account its resources. And so you'll see in the quotation there on the third page of my remarks from the South African case called Mezibuko. In the second paragraph, the court says, in doing so, this approach enables citizens to monitor government's performance and to hold it accountable politically if the standard is not achieved. This approach, and meaning the ESCR approach, also empowers citizens to hold government accountable through legal challenge if the standard set is unreasonable. In other words, the court can and does and will hear the evidence about whether government has done all that it can, and then decide whether those efforts have been reasonable, taking into account its resources. And again, I'm repeating myself here, but this comes from a perspective that says historically, the most disadvantaged, the most marginalized, a recognition that governments, democracies will very often take action or fail to take action, which may be acceptable to the vast majority of people, but which time and again either disregards or overwrites the interests of marginalized groups and equality-seeking groups. So are ESCRs possible in a poor country like Nepal, like many other countries? Is it possible? And when Justice Zak Yaqub from the Constitutional Court of South Africa was here this summer, he was asked that question, and he said, it's especially in a poor and least developed country such as Nepal that you need ESCRs. It's especially here. Because they are, disadvantaged people are far more likely to be politically voiceless, to be on the margins of the political process, and to having their interests and rights neglected by political elites and policymakers. So in that context, it would not only be pointless to look at the political process, it makes sense to have another avenue, a judicial avenue, for people to resort to. Okay, so let me comment on the draft that has been released by the Fundamental Rights Committee. And I want to say, first of all, that how proud Nepalis should be for what is a remarkable concept paper that shows a lot of commitment and dedication to the concerns and interests of all Nepalis. I frankly think that it's a tremendous effort, and members of the committee and Nepalis generally should be very pleased. Let me offer, however, some constructive advice and recommendations. And I've set them out in my paper, the last 2 or 3 pages, on the equality rights provisions. When you look at it, and go to the CCD website, the Center for Constitutional Dialogue, they have an interesting page there that has previous constitutions from Nepal. compare the equality rights, the anti-discrimination provisions, to that which existed in the 1990 Constitution, to that which existed in the 60s, and going back to 51. Lo and behold, the wording is pretty well identical. And so from a real world point of view, ask yourself the question, if discrimination against women on the basis of caste, on the basis of disability and so on have been prohibited for 50 years, why are the problems just as pervasive as they were 50 years ago? And I think the answer is it's a several-fold answer. Part of it is implementing and enforcing laws, and for sure that's a problem. I think another thing that it points to, however, is that the text of the provisions needs to be strengthened, more robust. It needs to take on not just formal equality that prohibits laws which single out particular groups, but it also needs to require substantive equality. And that, I understand, for many people is a kind of a new idea, a vague idea, an abstract idea. It's about looking at the effects of laws, the effects of government inaction, and saying, for example, if health services are supposedly equally provided, but when we look in fact, who gets health services in Nepal and who doesn't? If the people of Jajarkot and Rukam have unequal access, in fact, to health services, then that should be seen as a violation of equality, of substantive equality. Similarly, the concept of adverse effect discrimination needs to be explicitly provided for in the Equality Rights Guarantee. That's a provision that says everyone's entitled access to this room, but if in fact there is no wheelchair ramp, then people with disabilities don't have access to the room in a substantive sense. So that notion of adverse effect equality needs to find its way into the Equality Rights Guarantee. Quickly moving along, Article 31 of the current draft is a real problem. And it's a real problem primarily because it's really unclear what it means. Is it a provision that says ESCRs, right to food, right to housing, are directive principles and guidelines, and that government should take steps to think about them? Or is it a principle that reminds government that these are real rights? I've spoken to at least a dozen Nepali lawyers about that, and there is no consensus. So the provision needs to, in my view, either one of two things should happen. Ideally, Article 31 should, and sub 1 and 2 should be removed, because if it simply means these rights are real, well, that's true of all rights, and we don't need to be told that. The alternative approach, and I've set it out on the second last page of my paper, is think the fundamental rights provision should also have an interpretation clause that refers to Nepal's international human rights commitments and that directs courts interpreting the fundamental rights to apply them in a manner which is consistent with Nepal's obligations. This could be a very simple clause inserted, but it provides a bridge between what Nepal has agreed to internationally and what it's committed to domestically. Lastly, and this is a topic which I've put many people to sleep with at parties and other social events, is the idea of fiscal federalism. And that is to say, the federalism aspects of the Constitution, which are crucially important, which are not yet fully known by Nepalis, need to bear in mind the responsibilities and fundamental rights of Nepalis. And let me concretize what I'm talking about. The right to education, the right to housing. When Nepalis read that, they'll say, great. If, for example, the right to housing or the right to education falls on the provincial or the local or state level governments, it will be crucially important that those potentially financially very important obligations are matched by fiscal resources coming from the national government. And so that, in simple terms, that the state level governments have the financial or fiscal capacity to discharge their obligations that have been created by the fundamental rights provisions. And I know this is a bit esoteric, but it's also crucially important. As someone who comes from a country where this is an ongoing source of debate, I would just point this out and flag it so that when the Constitutional Committee releases its draft provision, those who are interested in this area need to ask themselves the simple question, does that level of government, which has very important and very costly financial rights obligations, does it have or will it have the financial capacity to discharge those obligations? Thank you very much. Dhanyavad.
Thank you, Mr. Vicent Calderhead. Of course, he has given very thought-provoking ideas regarding the human rights, particularly what I have found that he has given the very pertinent aspect. He has given very nice argument regarding the protection and promotion of human rights, and he has stated that human rights are of crucial importance, and since we are committed, the Nepalese are committed to human rights, so they are to have a due consideration regarding the human rights. The other point he has raised is the right to equality, and the third point he has stated is that social injustice is found so far as the protection and promotion of human rights are concerned in the Nepalese perspective, and he has stated that even in Canada there are several defects so far as the exclusive aspects of the human rights are concerned. Once again, I thank him, and now I duly request Dr. Mario Gomez to have his deliberations on comparative experiences with regard to socio-economic rights. Dr. Gomez, please.
I'd like to join the other foreign participants in thanking the organizers for this invitation. It's an honor to be here at this historical moment. One of the features of modern constitution making has been the inclusion of enforceable socio-economic rights together with civil and political rights as part of a larger Bill of Rights. Whereas many previous constitutions, especially those in the global south, place socio-economic rights as part of a non-enforceable principles of state policy, many modern constitutions now give both categories of rights equal status and make them both justiciable. This trend in modern constitution making reflects some of the developments at the international level. Since the Vienna World Conference in 1993, there have been increasing international attempts to try and give parity of status to both sets of rights, economic and social, as well as civil and political. The adoption of an optional protocol about a year ago by the UN was in some senses a culmination of many of these international efforts. Accompanying the trends at the international level is a huge burst of litigation at the domestic level. In common law countries, in civil law countries, across almost all continents of the world, there's been a flurry of litigation around economic and social rights, and courts are now providing enforceable legal remedies through interpretation of these rights. Now, this has happened in two ways. In countries where there has been no explicit charter on socioeconomic rights, courts have recognized rights through a process of interpretation and by implication. South Asia, I think, is a classic example of this approach. Most of the countries of South Asia do not explicitly recognize socioeconomic rights, barring a few labor-related rights. Yet the courts of Bangladesh, India, Pakistan, and Sri Lanka have gone ahead and implemented socioeconomic rights by way of interpretation and by way of implication. On the other hand, in countries like South Africa, Colombia, and Argentina, the Constitution explicitly recognizes socioeconomic rights, and this has provided a stronger conceptual base for courts from those countries to give effect to these rights. Several regional human rights bodies have also begun to interpret socioeconomic rights as part of their work. Previously, the debates in this area revolved around whether socioeconomic rights could be supervised and implemented by way of the courts. I think the debate has now moved on. The debates today center on how best can courts recognize these rights. What new remedies should the courts devise to ensure effective implementation? How can these rights be enforced against private actors? And how should the courts balance progressive realization with immediate implementation? Now, one of the features of the international discourse on socioeconomic rights is the distinction, or is a concept of the progressive nature of these rights. The International Covenant subjects all these rights to the qualification that their full realization must be progressively achieved according to maximum available resources. The South African Bill of Rights still remains a source of much inspiration. Although much has been written and spoken about it, the way the South African Constitution entrenches socioeconomic rights provides guidance for any other constitution-making exercise. One of the key points about the South African Constitution is the distinction the Constitution draws between one category of socioeconomic rights, which are immediately enforceable, and another set which must be implemented progressively, reasonably, and in accordance with available resources. Thus, the right to emergency medical treatment, the right to a basic education, and the right against forced evictions are among those rights that are capable of immediate implementation. In these cases, the state cannot argue that the lack of resources prevents it from guaranteeing these rights immediately, since the constitutional right is couched in extremely categorical terms. Other rights, such as the right to adequate housing, the right to healthcare services, reproductive healthcare, sufficient food and water, and to further education, are to be achieved progressively. The Constitution recognizes that these rights cannot be enforced immediately and instead requires the state to take reasonable measures within available resources to achieve the realization of these rights. Now, if you look at the Colombian Constitutional Court, we can see a similar. Colombia entrenched socioeconomic rights in its 1991 constitution and entrusted the Constitutional Court with the task of safeguarding the integrity. And the court has held that some of these rights may be immediately enforceable given the right set of circumstances. So therefore, where it could be established that a violation of a socioeconomic right will affect fundamental rights where there was an unconstitutional state of affairs, then the Constitutional Court of Colombia has shown a willingness to implement socioeconomic rights immediately. So for example, although the right to social individual or his or her family to take action to remedy the situation, where the state has the possibility to remedy the individual's ability to enjoy minimum conditions of a dignified life, which government conduct cannot sink, and where human dignity is affected, then the courts have shown a willingness to immediately implement socioeconomic rights. The concept of an unconstitutional state of affairs has also attracted cannot be attributed to only one state authority, then the court has shown a willingness to grant remedies immediately. Now, elements of this human dignity approach are captured in the draft dignity, would allow a future Nepali court to order the immediate implementation of socioeconomic rights where the violation is widespread or gross, so as to violate a person's dignity. I think what the jurisprudence of the courts of South Africa, Colombia, and spread, then it is possible, and the state has a capacity to respond to the violation, then it is possible to implement these rights. It will no doubt be an ad hoc process of judicial interpretation. It would include socioeconomic rights in its Bill of Rights. Then one particular challenge that the courts will face will relate to remedies. What remedies are best suited to enforcing socioeconomic rights and converting a legal judgment into something concrete that can potentially make a difference in the lives of the poor and the disadvantaged? While the courts of South Asia have come up with several important judgments on socioeconomic rights over the years, several of these judgments have remained in the law reports and have not been implemented as a matter of practice. One particular issue is, how does the court respond to the case before it, and also deal with many others in similar situations who might not be before the court? Similarly, how does the court address the larger structural or systemic issues that can be redressed only over a period of time? This is illustrated by an Indian case on emergency medical treatment, where a person fell off a train, he sought medical treatment from 4 state hospitals, he was turned down, and then he went to a private hospital and he paid a certain sum of money and he received treatment. Now the Indian court gave him compensation for the sum he had expended at the private hospital, But the Indian court also issued several recommendations on how public hospitals should be able to cope with emergencies. Now, how does the court supervise such orders? How does it respond to the larger systemic issues of public hospitals not being able to respond to emergencies such as this? I think partnerships with independent institutions, such as human rights commissions, gender equality commissions, and other such bodies, may be of use in such circumstances. In some countries, the courts have asked these independent institutions to monitor and supervise their orders, especially where they are complex and involve continuous monitoring over a period of time. I think the group boom case also illustrates this dilemma. Here you had 900 people who came before the Constitutional Court and sought a remedy. But there were obviously in South Africa many group boom type communities who did not come before the court. And when the court gave its order in that particular case, it has to be conscious of the fact that there were many other stakeholders who were not before the court. I think another issue that will trouble the court with regard to socioeconomic rights is how involved should the court get involved, how involved in the detail or the nitty-gritty should the court go. When Justice Goldstone of the South African Constitutional Court was interviewed after the group boom case, he said the court should not get involved in the nitty-gritty or detail of a case. The court could tell the government that it must devise a plan to cope with the housing needs of those in a situation of crisis. However, it cannot dictate to the government the details of such a plan. That, he said, would be a violation of the separation of powers doctrine. However, the South African courts have got involved in the detail, as illustrated by the recent Madzibuko case, where the court held that the supply of 25 liters of water per day or 6,000 liters of water per household for a month was not adequate to meet the standards in the Constitution. There, the court held that the installation of prepaid water meters in a poor neighborhood in South Africa was unconstitutional and asked the local council to increase the daily quota of water to 50 liters a day. And this, I think in relation to remedies, another trend that's emerging in some courts of the world is the question of a negotiated court settlement. In Argentina, for example, the court supervised the settlement between a local authority and a poor community to ensure that the homeless community got access to housing in Buenos Aires. And part of that settlement was a very interesting remedy that asked the local council to give preferences to builders who took at least 20% of their workforce from those of the homeless community. In South Africa, too, in a recent case, the Constitutional Court asked the Johannesburg local council to engage meaningfully with the community before it embarked on a forced eviction of people from unsafe accommodation. Another issue that's going to arise if a country constitutionalizes socioeconomic rights is how do you deal with private actors? The South African Constitution, for example, recognizes the question of horizontal application, that private actors may be directly liable in certain circumstances. Similarly, the Columbia Constitutional Court and the English courts have also shown a willingness to hold private actors liable, especially where they're performing a public function. Now, private actors could be addressed by way of separate legislation, the responsibility to protect, or by making the Bill of Rights directly enforceable against the private actor, as the South African Constitution has chosen to do. I just want to summarize some of the points, Mr. Chairman, with regard to socioeconomic rights. And I would like to suggest that if Nepal proceeds to include socioeconomic rights in its constitution, then the following are some issues that it should keep in mind. First among these questions is what rights should be included in the Bill of Rights. Apart from the rights contained in the international instruments and other bills of rights, a right to live with dignity would be a useful handle for a future Nepali court to respond to large-scale or widespread violations of socioeconomic rights, especially to secure immediate implementation of those rights. Immediate enforcement versus progressive realization. Which of these rights should be subject to progressive realization, if at all, and which should be made immediately enforceable? Should the Constitution mandate Parliament to pass legislation within a stipulated time frame? This appears to be the approach contained in the draft concept paper that the Constituent Assembly has put forward. Should the provisions on socio-economic rights in the Bill of Rights or in legislation be enforceable against private actors, and how should the relevant constitutional and statutory provisions be formulated? If you look at the South African formulation, the formulation is a little complicated. The question of standing. Who can bring an application before the court for the enforcement of fundamental rights? Here again, if you look at the South African Constitution, it's very broad, wide-ranging, and the Constitution allows a broad range of actors to come before the court to enforce fundamental rights. Another issue that would probably need to be addressed by the court is what sort of litigation model is best suited to the enforcement of economic, social, and cultural rights. I would like to submit that a litigation model that is inclusive, permits third parties and independent institutions to intervene would be more democratic and assist the courts in their task of interpretation. On remedies, of course, if court orders are to translate into action, then Nepali courts should be willing to explore a broad range of new remedies. Permitting the courts to issue a remedy that is just and equitable in the circumstances will enable the court to develop remedies that are appropriate for the enforcement of socio-economic rights.
Thank you, Mr. Mario Gomez. And particularly what I have observed that you have concentrated upon 2 points, that is the socio-economic rights relating to the contention that whether it should be immediate enforced, or the other, that is the progressive realization of the socio-economic rights. So 2 parts you have thrusted upon, and particularly in the Nepalese context, we have stated that what should be incorporated under the Bill of Rights is a matter of fact to be duly considered by the Nepalese people, and things that are to be taken into account on the basis of progressive realization. So 2 parts are there, and that is to be duly contemplated by the lawmaking bodies, constitution-making bodies, and by providing lot of informations and sharing views regarding the countries that have their own sort of the understanding of socio-economic rights that you have given here. So thank you for your so enthusiastic deliberations. And now the time is for the commentator, and particularly we are in time. The commentators are required to concentrate upon the time, and the time frame for the commentators is of 10 minutes as it is directed here. And first of all, I would like to request Jyoti Sangahara, HCHR, to have his deliberations or comments whatsoever she wishes to have before the House. Thank you.
Thank you very much. Thank you, Chair. And thank you indeed to Vincent and Mario for very thought-provoking and extremely useful presentations. Beyond what you have already pointed out, I am afraid I may not have anything scintillating to say, but just a few thoughts to share with you on the issue of economic, social, cultural rights here. Having come from an earlier session which focused on national interests and constitution writing, it was pointed out that the national interest and indeed national security of Nepal is not in the danger of being threatened by an encroachment of security forces from India or China, its neighbors, or from any of its neighbors. But indeed, the national interest of the country stands in danger of being threatened from internal tensions. And these tensions have to do with the question of human security, linked to human development, and indeed, in this case, very much linked to economic, social, cultural rights and denial of these rights. Because if we understand the conflict, it indeed had to do with economic social justice. So if that is our understanding, then how do we write economic, social, cultural rights into the Constitution and prioritize these rights, center them in the Constitution? And if we recognize that Constitution drafting and Constitution making is a tool for nation building, particularly a country which is fledgling, which is coming into its own, then what is the centrality we give to economic, social, cultural rights in order to allay any further fears, concerns around conflict, and in a country which is deemed post-conflict now. I also, like Vincent, come from Canada, but I also come from this region, having worked in Sri Lanka and now in Nepal. So I think I can say that neither in the global north nor in the global south is jurisprudence around economic, social, cultural rights fully cooked. It's very nascent, it's in the process of developing, and I think Nepal faces this very historic moment, and we are all a part of it, where the nation is drafting a constitution. It's the first of the nations in South Asia, which is now in the process of drafting a constitution. The others already have done it. And what are the lessons that we can learn in this process, and what can we bring to this process of constitution drafting? Constitutionalism is also about a combination of text and process, as has been amply pointed out by a number of people in the course of these sessions. And the process, particularly in the context of economic, social, cultural rights, is key. It's very, very critical. And in this area, some of our own work, the work of my organization, OHCHR, has seen a conflict between competing rights, particularly when it comes to economic, social, cultural rights. Just to give you an example, the right to water, was being enforced or implemented in a village where water wells and the source of water was provided to the villagers. However, it's wells in the Dalit section. Now here we have both the Dalit and the elite section of the village having access to water, and the work may have been done. But what does it do to discrimination? How does it foster existing social values, which create these fissures? And there could be a number of examples that we could talk, particularly in relation to women's rights as well, where there are competing rights which then the tension begins to grow. For instance, the right to women's mobility in Nepal being contravened by the right to freedom from abuse, in that women are not able to travel to certain countries in the Gulf, in a bid to protect them from trafficking and other forms of exploitation. So I think when it really comes to implementing economic, social, cultural rights, the whole understanding around how rights compete and contravene each other need to be better understood. And lessons could be learned from a number of cases, even within the sub-region, within the South Asian sub-region. Mario and Vincent have very skillfully pointed out that some of the key issues around economic, social, cultural rights are, for instance, the tension between immediate implementation and progressively realizable rights. This is again something that we are noticing actually on the ground. Of course, justiciability is a very important issue as well. But how does one really, on the ground, resolve these tensions? Because the demand from the communities is for immediate implementation of rights.